She did not deserve this. She was a good person.
Put the gun to whose face?
Jake's face.
And then what happened?
Well, he solicited someone to kill me from jail, so it doesn't really give much.
I just want everybody to know today that I'm extremely sorry. And I take...
A murder case with Hollywood-like elements, including a poisoned husband, a staged death scene, and a beautiful woman sentenced to life in prison, may be heading back to court. Attorneys for Kristen Rossum are seeking to reopen her case for a new trial. In 2002, Kristen Rossum, a toxicologist with the San Diego County Medical Examiner's Office, was convicted of poisoning her husband and attempting to stage the scene to look like a suicide, drawing inspiration from a popular movie at the time. A video of Kristen walking to court, tightly holding hands with her parents just before her murder conviction. The victim was her husband, Greg DeVilliers. She claimed he was depressed about their crumbling marriage and had taken his own life. The cause of death was an overdose of the painkiller fentanyl, and a quantity of it was found missing from the county medical examiner's office, where Kristen worked. She was ultimately convicted and sentenced to life without the possibility of parole. Now, another attorney is pushing to retest DeVilliers' blood samples from nearly 13 years ago.
And what we seek in this motion is to retest the autopsy samples to see if there are fentanyl metabolites in these samples.
That test alone might not yield conclusive results, but she hopes to find a way to determine if the samples could have been contaminated in the lab.
If there are no metabolites of fentanyl, then we have the issue of, has there been degradation? What does that mean? We're steps away from a motion for new trial. Is that the direction that I would like to see it go? Yes, but we're very far from that right now. We're just trying to get the testing done.
The DA is opposed to reopening the case.
Our position is there is no contamination. It couldn't be proven at this late date. And the fact of the matter is that the victim died of poisoning, whether it was fentanyl or some other poison that was found in his system. The fact is that he was poisoned to death and that Ms. Rossum is responsible for that.
The murder case has captivated, inspiring 2 books and featuring segments on 4 TV shows. Now, new developments may be on the horizon. Additionally, there is a $100 million civil suit judgment against her from the victim's parents. While they don't expect to see any of that money, they at least don't want her to profit from it either. Another courtroom outburst occurred from a South Florida man accused of killing his estranged wife. Sid Torrez was very vocal in court once again. Before his hearing concluded, he looked directly into the cameras and made bizarre statements, saying things like, "Let the witch hunt end," and "Call the Secret Service and FBI." This was all before bailiffs had to subdue him and take him away.
The witch hunt ends here.
Torrez, who was convicted over the summer for murdering his wife, Violet Torrez, made more erratic statements in court. Once the hearing wrapped up, he wanted to address the judge, but she denied his request because the prosecution had already left. That's when he looked toward our cameras and asked us to call the Secret Service, the Commander-in-Chief, and the FBI. This is the second time he has made such remarks. He first did so earlier during his sentencing hearing, which prevented the sentencing from taking place. During that hearing, Torrez told his attorney that he had been hearing voices for months, raising questions about his mental competency during the trial. The prosecution and defense want to review his phone calls to see if any bizarre statements were made. However, the judge dismissed these concerns, stating that he seemed fine to her every time she spoke to Torrez.
All can agree that Mr. Torrez did not say or do anything during the trial that either you or the court or the state would have called into question his competency.
Torrez was last seen on surveillance video leaving his gated community sometime after 5 p.m. on March 31st, 2012. His eldest daughter testified during his trial this summer that he was at home the last time Waire was seen alive. Detectives also reported that cadaver dogs detected an odor in Torrez's trunk, the back seat of his car, and at the couple's home. A woman found guilty of murdering a co-worker learned her fate, and the victim's family urged the judge to impose the maximum punishment.
She did not deserve this. She was a good person.
The courtroom was filled with emotion as the family of Domini Johnson addressed the Cuyahoga County judge, pleading for the killer to be locked away for good.
She was always there for me whenever I needed her.
Chappelle was found guilty of shooting and killing Johnson. He also shot another woman, who survived to share her story in front of the judge.
Every day I wake up, it's just a constant reminder of what happened that night.
The shooting occurred in the parking lot where Johnson and Chappelle worked, in Cleveland's Jefferson neighborhood, on an avenue behind the Target on West 117th Street. It took place early on Thanksgiving morning in 2021, a day meant to gather with loved ones.
You sought her out, you waited for her, and you executed her.
The judge sentenced Chappelle to 43.5 years to life in prison. During the hearing, Chappelle apologized to Johnson's family.
I just want everybody to know today that I'm extremely sorry, and I take whatever you give me, Your Honor.
Once again, the judge noted that the murder took place in this parking lot, stating that if Chappelle hadn't had access to a gun, they wouldn't be in this situation. He urged the Chappelle family to help get guns off the streets. The Nairobi High Court has sentenced Ruth Kamande, the 2016 Miss Langata Prison Beauty Pageant winner, to death for the murder of her boyfriend, Farid Muhammad, in 2015. During sentencing, the court noted that Kamande did not claim she acted out of anguish or despair. Instead, it was clear she intended to cause the deceased pain, suffering, and death. At the time of the killing, Kamande was only 21 years old and had just enrolled to study business. The family of the late Farid Muhammad expressed satisfaction with the conviction.
I find that the accused person deliberately stabbed the deceased with the clear intention to cause him pain, suffering, and death. And I've taken into account, I want young people to know that it is not cool to kill your boyfriend or girlfriend, even where you feel disappointed or frustrated. Don't do it. Instead, it is cool to walk away and thereafter to forgive. Now, after considering all these factors, I find that the only sentence to pass in this case is death, and therefore sentence the accused person to death as prescribed by the law.
But I was hoping for life sentence. We are Christians, but we just wanted to thank the court and the justice in Kenya. Now we believe that there's justice in Kenya. That's the most important thing, that people cannot go taking other people's lives just because one is frustrated.
Ruth Kamande was sentenced to death for the murder of her boyfriend, Farid Muhammad. Video extracts from the preliminary examination for Jordan Waire, who faces 6 counts related to the death of Western Michigan University student Jacob Jones, were presented in court. These charges include felony murder, armed robbery, and weapons offenses. Testimony was given by a forensics doctor, an eyewitness, and former WMU basketball player Jovier Kennedy, who was with Waire during the armed robbery at the Soho apartments. Kennedy testified that the armed robbery attempt by the 2 former Muskegon High School basketball teammates did not go as planned. Tragically, the Western Michigan University student was left dead on the floor of his apartment after Waire pointed a handgun at Jones's head. Following the testimony, Kalamazoo County District Court Judge Robert C. Kropf ruled that there was enough evidence against Jordan Waire to send the case to trial in circuit court.
Can you explain to the court what you did as part of your autopsy to determine the cause of death and the manner of death in this case? A reasonable degree of medical certainty, can you tell us the cause of Jacob R. Jones?
Yes.
And what was that, doctor?
He died of a gunshot wound of the face.
And you said the red bandana man pushed Jacob?
Onto the couch when he tried to stand up with his hands up.
And then what happened?
And then he said, "No, I can seriously get you anything you want," and tried to stand up again. And that's when he put the to his face.
And when you say he,
the red bandana.
Put the gun to whose face?
Jake's face.
And then what happened?
He shot him.
And what happened after he shot Jacob Jones?
Jake fell to the ground.
Did you see Jacob move after that at all?
No. And then I saw his pool around his head.
So he put, the red bandana man put the gun to your head?
He put it to my face.
And then what happened?
And then I gave him my phone.
Why?
He said, "Give me that."
The red bandana said, "Give me that"?
And took my phone.
At some point, did you go to Meyer's grocery store with Jordan Waire?
Yes.
Who was with you when you went to purchase these bullets?
Only me and Jordan Waire.
Where was Jordan Waire?
Can you be more specific?
Sure. When you purchased the bullets, where was Jordan Waire?
By my side or behind me.
Okay.
He just got a new sir.
And what kind of gun was it, you know?
I'm not sure, sir.
What, did he tell you what kind of gun it was?
He said it was a 40, sir.
A 40? Did he have bullets for the gun?
Yes, sir. Jordan told me, sir.
Now, did Jordan ask you to do anything that evening with him?
Yes, sir.
What specifically did he ask you to do?
To rob someone, sir.
How did Jordan ask you to rob someone, or what did he say to you that led you to believe he wanted to rob someone that evening?
He said, do you know anyone that we can rob, sir?
Those were his specific words.
Yes, sir.
What was the original plan going to be if you set up a 3-gram deal of weed with Jacob?
He was going to go in, sir, and I was going to be the driver.
And was the gun that he showed you in his apartment going to be involved in this?
Yes, sir.
How do you know that?
Because he brought it in.
So, you did not go into the Soho apartment the first time you got there, is that right?
Yes, sir.
What did you do?
We turned around and went back to Copper Beach.
Why did you do that?
So I can change clothes, sir.
Why did you want to change clothes?
So that we can rob Jacob, sir.
Why did you ever need to change clothes?
Because I had on Western Michigan basketball gear.
Did you also have a mask or something that you gave Jordan?
I gave him a bandana, sir.
Why did you give him a bandana?
So he can cover his face, sir.
So was it you or was it Jordan that knocked on the door?
Jordan, sir.
And then what happened when the door opened?
He came into the house, sir, and I came in second. And
Was there anything said?
I'm not sure, sir.
Was there anything said by Jordan when you went in the apartment?
I'm not sure, sir.
What happened when you got in the apartment?
He pointed to everybody, sir.
Who pointed the gun?
Jordan. They said we don't have any guns, sir. And he pointed to the gun to Jacob, sir.
And then what did you do?
Then he shot him.
Use numbers 1 through 4 and mark where those occupants were.
I guess I'd object. It also could be 1 through 5, depending on which testimony you believe.
Okay, if there were 5, use 5. Anyways, use the numbers. Okay. Now, you testified that you gave Jordan a red bandana, correct?
Yes, sir.
At what point in time in this evening did you hand that red bandana to Jordan?
In the car, going to the Soho the second time, sir.
The second time.
Yes, sir.
And you're sure it was red?
Yes, sir.
Why did you have a red bandana?
Because I'm affiliated with the Blood, sir.
And their color is red, correct?
Yes, sir.
A trail of evidence led to the conviction of Julio Martinez Santana, a Tampa man who stalked and attacked a woman nearly 4 years ago. Now, he is headed to prison. However, before his sentencing, Santana addressed the court without offering an apology or showing any remorse. Instead, he maintained his innocence, claiming he was wrongfully convicted.
I was wrongfully convicted because my counsel failed to cross-examine the alleged victim on her critical testimony.
During sentencing, prosecutors emphasized to the court that Julio Martinez Santana is a repeat offender and argued that he should receive a life sentence.
He's also a very dangerous and violent man.
In December, a jury found Julio Martinez Santana guilty of all charges, including aggravated stalking and aggravated battery with a deadly weapon.
My name is Ashley Anderson.
During the trial, Ashley Anderson testified that Julio Martinez Santana became obsessed with her after she refused to date him. She stated that his obsession nearly turned deadly. On the night of August 1st, 2019, Anderson recounted how Martinez Santana emerged from the shadows and attacked her outside her home.
And hit me so hard in the back of the head that I rolled inside my house. And he just gets on top of me and puts his hands around my throat.
Prosecutors stated that Julio Martinez Santana was armed with a knife during the attack.
I was scared. I knew I had to find some way to get him off me. I mean, he told me I'd never see my son again.
During the struggle, Ashley Anderson managed to knock Julio Martinez Santana off of her, forcing him out of the house and leaving behind a trail of evidence that ultimately led to his conviction. 5 months later, the judge delivered a severe sentence.
Count 1, the armed burglary of a dwelling with assault or battery. I'll sentence you to life in prison.
Martinez Santana will spend the rest of his life behind bars. A judge sentenced Gabriel Ramirez to 20 years in prison for stalking a young girl and shooting her father. Part of the evidence against Ramirez included the numerous tattoos on his body featuring the girl's name. Ramirez shot the girl's father after he confronted Ramirez and demanded that he stop stalking his daughter. Ramirez showed little reaction when the judge handed down the maximum sentence allowed for the assault charge. The harsh penalty seemed almost inevitable, especially given Ramirez's confusing and contradictory testimony when he took the stand in his defense, along with the damning evidence of his tattoos, which demonstrated his obsession.
That T on your arm is for Trejo.
I mean, it could stand for a lot of things.
Gabriel Ramirez, 23, was evasive when questioned about the 11 tattoos on his neck, chest, and arms, all of which bore the name Cristina Trejo. Ramirez admitted that he began stalking Cristina when she was just a teen. When asked about the significance of the numbers tattooed across his body, Ramirez claimed he did not know their meaning, even though they were linked to Cristina's birth date. He told the judge he only learned the significance of the numbers when he was indicted.
I went to try to open the door.
Cristina's father, Antonio Trejo, spoke in court with the help of a translator. He told Ramirez to stay away from his daughter, but Ramirez didn't listen. On June 6, 2013, Ramirez came to their house and shot Antonio 3 times up close. In court, pictures were showing the bullet holes in the front door.
Well, right away when he arrived, he started firing.
Ramirez pleaded guilty, claiming he didn't remember much about that day.
My memory is a little blurred.
But he clearly remembered the long list of hard drugs he had used before he started shooting.
I took heroin, cocaine, weed, with a little PCP in it, bars, Xanax bars.
Even after being jailed for the shooting, Ramirez kept sending letters to Cristina and her parents.
She's very scared. She didn't want to be here.
Cristina didn't testify, but was present when Ramirez was sentenced. Prosecutors mentioned that the family finally feels some relief now that Ramirez is going to prison.
Probably one of the more severe stalking cases that's come across this court. It's certainly the worst I've seen in my career.
The Trejo family chose not to speak to the media after the verdict, but appeared relieved. Amina mentioned that Ramirez expressed regret from the stand and asked the court for a second chance. However, the judge didn't agree with that. Ramirez was sentenced to 20 years in prison and will be eligible for parole after serving about half of that time. Since he has already been in for a year, he could be eligible for parole in 9 years. After the verdict, the prosecutor said the Trejo family plans to stay involved in the case to help ensure that Ramirez serves his full 20 years. A convicted serial stalker is going back to prison and sentenced to a mandatory 22 years. In 2011, his victims shared their concerns. 2 years later, Damon Haynes was released from jail, but now he's back behind bars for stalking another victim in Omaha. Haynes claims he was trying to check on his young daughter's safety while in jail. However, prosecutors have a lot of evidence, including reports and phone records, showing that he was threatening the girl's mother and her family.
He kicked in my door twice, busted my windows, broke in my house, stole my clothes.
In 2011, 3 women who wished to remain anonymous shared their terrifying experiences with Damon Haynes, who was serving time for stalking. They described how he threatened their children, watched them both inside and outside their homes, and emotionally abused them. One of the women recalled him asking if she believed the police could keep her safe. After being released in July 2013, Haynes was sentenced today to 24 to 48 years in prison for stalking, making terroristic threats, and being a habitual criminal. The victim involved is the mother of one of his children. Investigators used our 2011 story to help her recognize the abuse she had been enduring from Haynes.
When the victim in this case came forward, we said, "Do you understand who this individual is?" And she viewed that video as well as these other people he was manipulating from behind bars.
Haynes insists he was looking out for his daughter. However, investigators revealed that he called the victim 44 times from jail and made other threats against her life. Prosecutors stated that he has stalked around 24 people since 1999. Judge Shelley Stratman described him as one of the worst domestic violence offenders she has ever encountered and noted that he shows no remorse for the lives he has affected.
It's not a loss of life, but it is a loss. And it's a loss of something bigger. It's a loss of stability, of their house, of their safety, of their home, the safety of their children. These victims are in therapy. Many wouldn't come forward. Our own victim in this case today was too scared to come, too scared to make a statement, because they will forever live with that.
Haynes will serve a minimum of 22 years in prison with a mandatory release date of 38 years. It's shocking how frequently he has been convicted of these offenses. The judge emphasized that being imprisoned didn't deter him at all. She pointed out that he was repeatedly warned not to contact the victim, yet he persisted. Investigators intercepted letters and phone calls revealing that he was manipulating and harassing about 30 different people, trying to rally them to his side. In a disturbing twist, he even had his son, who is currently facing a first-degree murder charge, reach out to the victim's family and threaten to shoot up their home. A man is going to prison for stalking his ex-girlfriend, who lost her job because of his actions. In court, Kevin Singh took 45 minutes to tell the judge that he wasn't guilty of stalking. Despite his explanation, the judge remained convinced of his guilt and sentenced him to 8 years in prison for stalking and being a habitual offender. His former girlfriend, Whitney Walkers, appeared dazed as she left the courtroom after the sentencing.
I don't know how I feel right now.
He is going to prison.
Yes.
That doesn't make you feel safe now?
Well, he solicited someone to kill me from jail, so it doesn't really give much hope.
Prosecutors stated that Singh made Walker's life a living hell.
She walks around with 911 dialed on her phone now when she's out walking her dog, just to remember to hit send in case something happens. She's lost sleep, she's lost weight, she's lost time, she's lost a job.
She was fired from her job at Nordstrom due to her ex-boyfriend's stalking, as the store was concerned for the safety of its employees. They initially offered Walker $5,000 payment to leave, but later retracted it. After contacting investigators, the store eventually provided her with the money. Meanwhile, Singh has continued to assert his innocence, and his attorney has partially blamed the victim for the situation.
Well, he got involved with a woman who does not feel any compunction at blackmailing and threatening and falsifying messages.
Singh's legal troubles are far from over. He has another pending trial for invasion of privacy. Kylell Brown, a former employee at Diamond High School, was sentenced to just over 2 years in jail after Superior Court Judge Peter Ramgren accepted his plea deal. Brown apologized in court, but the family involved is not completely satisfied with his sentence or his statement.
I'll accept this agreement, and I will sentence the defendant pursuant to the agreement.
Kylell Brown, a former security guard and basketball coach at Diamond High School, was sentenced to 60 months, with 33 months suspended, after a plea deal in which he admitted guilt to a charge related to a minor. Alyssa Powell, the student's mother, believes the sentence does not represent true justice, as Brown is expected to be released before her daughter finishes high school.
Have graduated high school, because I know that that was part of the plea deal that the prosecutor worked into the agreement, and so this has derailed her school, her high school, so I don't think it's enough time.
During sentencing, a legal representative read a statement from the student who Brown abused. She expressed a desire for the seriousness of the crime to be acknowledged to help prevent it from happening to others, and mentioned that she is ready to begin her healing process.
The trauma from this will follow me for the rest of my life. It has impacted my ability to maintain relationships and pursue my high school education. I worry about how this will affect my future, both personally and professionally. The dreams I once had seem overshadowed by the darkness of what happened.
The teen's parents say their lives changed dramatically when they were informed by the police early last year that Brown had misused his position of authority about their daughter.
There are no physical scars visible. The abuse that has endured
has taken a toll on her physical and mental well-being. She experiences acute stress disorder and post-traumatic stress disorder, and her life is no longer as it was.
Brown apologized for his actions, expressing a desire to improve himself for the sake of his family, including his wife and children.
My decisions and actions affect everyone in the courtroom, but no one more than her parents and her family. I was someone she trusted, and I felt her miserably. Hurts me even knowing the long-term effects this could cause her physically and mentally. The effects on her views on relationships or love can be hurt forever, and I put her in that situation.
In addition to prison time, Brown's admission of guilt resulted in a sentence of 10 years of probation. He will also be required to register for a specific period after the probation ends. Judge Ramgren is requiring Brown to pay restitution, though the amount has not yet been determined. On December 20th, 1984, Janelle Matthews disappeared from her Colorado home. Decades later, in 2019, Steve Pankey was arrested for her murder. During the court proceedings, the prosecutor detailed the horrific crime, bringing the nearly forgotten case back into the spotlight and rekindling the fears and emotions of everyone involved.
Jim Matthews returned back home after watching his daughter Jennifer play basketball, and he gets home about 9:30. Mr. Matthews walks in the home, yells, "Hi, Janelle," goes downstairs to wrap a Christmas present. He didn't get a response. But at that first moment, nothing particularly odd was crossing Mr. Matthews' mind. So he started to wrap the present, he walked back out, and he realized he hadn't heard Janelle. So he repeats himself, "Hi, Janelle," no response. He walks out into the living room area in the basement. He sees that the television is on, the space heater is on, the chair in the foreground, a chair where Janelle often sat and watched television, worked on her Christmas presents for her friends. On the couch on the right-hand side of that photograph, for the record, this is People's Exhibit number 41, you see Janelle's pantyhose. At the base of that chair, you see the dress shoes that she wore to the concert. And when you get this exhibit, if you look closely, over the top of one of her shoes is a piece of red thread, similar to that which would be used for cross-stitching. Mr. Matthews looked around the home, and other than a jewelry box that was in his and Gloria's bedroom, which was laying open, albeit nothing seemingly missing from that jewelry box, nothing seemed out of place. Mr. Matthews called Russ Ross at about 10 o'clock that evening to make sure that he had in fact gotten Janelle home. And when he gets confirmation that yes, in fact, Deanna and I dropped Janelle off at the home, he called his pastor, Jim Christie, for guidance, advice. What do I do? I can't find my daughter. Jennifer gets home from the basketball game, and Mr. Matthews tells her that they can't find Janelle. She suggests they start calling friends. No response. No one has seen Janelle. At 11:14, the Greeley Police Department is called. Now, contrary to what we hear in the social media, ladies and gentlemen, police don't wait 24 hours, 48 hours before beginning to act upon a missing child, particularly a 12-year-old missing child 5 days before Christmas. You'll hear that Officer Dave Mathis was the first officer to respond, followed closely by other officers, including Detective Jack Stollard. And as they start looking around the outside of the Matthews home, they see footprints in the snow. Shoe prints are on the back of the Matthews home, up a back staircase to a deck that leads to a landing to the back door, kitchen door. Similar shoe prints from the front porch area, walking in front of the Matthews home, back towards the front porch. And they also notice something interesting. The shoe prints in the backyard have been raked out, obliterated by a hard rake. Exhibit 10. Obliterated by a hard rake very similar to one that was in the Matthews garage. When they go in the garage, they see a grease spot or an oil spot as if a car had leaked some oil. And there are some very distinctive similar shoe prints in the grease, in the oil, in the garage of the Matthews home as well. The evidence of this raking in Exhibit 10 and other exhibits that you'll see was held very close to the vest by the Greeley Police Department for years and years, knowing that the only other people who would, or other person who would know that that raking occurred was the person who did it. Years later, Jennifer Matthews did not know that the snow in the back of her house was raked. That's how close to the vest the police department kept this. Having seemingly vanished into thin air, Janelle was missing for the next 35 years. Now, here in Greeley, this was enormous news. Missing persons posters with Janelle's face were everywhere. A community was terrified. The news media came up and covered the story almost on a daily basis. Television production companies did recreations of her disappearance, trying to get the word out about Janelle being missing. Even President Ronald Reagan mentioned Janelle by name in a speech about the epidemic of missing children to a national newspaper organization. Janelle was one of the first children featured on milk cartons under the phrase, "Have you seen me?" that you were told no one would believe.
I can't remember right now.
Oh, it's convenient that you can't remember something that happened yesterday.
I can't remember.
There were other times where you would give an answer and you were told, that's a good answer.
Objection. Attorney-client privilege.
Overruled for the same reasons I indicated on the record.
Yes.
What were those answers? Can you remember those?
Not right now.
And do you recall telling this jury that when you were in the cubicle before coming to testify, that you prayed on the topic, and you told us maybe I shouldn't testify because I would just be telling more lies? Remember that?
I don't remember that exactly.
I'm totally humiliated. I wanted this handled in a lesser way.
Yes.
You told this jury yesterday that when you had met with Detective Statler and Agent Lyon, the basic reason that you were doing this was to get even with them. Right? That's what you told them yesterday.
I don't remember exactly saying that.
You went on to say, but in fact, there were some people in there that made statements in the 1976, 1977 period that would be considered racial. What does that mean?
You talking about at Sunnyview?
I don't know. You said it. I'm asking you what it meant.
It meant that there were statements that were made that would be not politically correct, I guess, today.
So when you're talking about in there, in there means in the church.
Yes.
And you felt really good after talking with law enforcement.
Yes.
You felt really good because they didn't have a clue you were a suspect at that point, right?
No.
You very specifically told this jury you did not talk to your father-in-law on December 27, 1984.
Yes.
And you were asked why you said that, or why you said you did. Quote, I said it to keep the lies, to keep the story going, right?
I don't remember exactly saying that, but I don't deny it.
One lie leads to another?
Yes.
And then you were specifically asked again, why did you say you did talk to him if it wasn't true? Remember being asked a couple of times? Being asked that a couple of times.
I can't remember specifically being asked that, but I believe you that I was.
And you responded to your attorney again, quote, I needed an explanation as to what conversations I had, and that came to mind. What conversations did you need to explain?
Well, I don't know. I don't remember the context you're talking about.
I just gave it to you. You were asked, why did you say you had talked to Harold Hicks if it wasn't true? Your answer, I needed an explanation as to what conversations I had, and that came to mind. What conversations?
Oh, that goes back to 1977 at the church, at Sunnyview Church of the Nazarene.
What conversations did you have in 1977 at the church, the Sunnyview Church of the Nazarene, that were relevant to whether or not you talked to Harold Hicks on December 27th, 1984.
Specifically, I guess there is no correlation there.
So that was just a nonsensical answer to a fairly straightforward question then? Is that what I understand?
No.
You also told this jury that you wanted to be consistently inconsistent in case Jim Matthews was ever arrested.
I did not want to be a witness against him.
You told this jury you never knew who Mr. Matthews was. How in the world would you be a witness?
I think I made it clear yesterday that Lieutenant Sun Valley Police Lieutenant Mark Lockwood.
Oh, trust me, we'll talk about that, Mr. Pankey, but that doesn't answer my question. You told this jury you never knew who Mr. Matthews was, yet you believed you were going to be called as a witness against him if he was ever arrested?
By what Lieutenant Mark Lockwood said, and yes, I never met the man.
For the past 2 years, you, Steve Pankey, have been in jail for the murder of our daughter Janelle. You've been free for almost 35 years without paying for this crime. This crime has haunted our family all these years. But as these 2 trials have shown, you have been obsessed with your actions and your conscience could not let you forget. You have been a prisoner in your own mind. You've claimed to be a Christian on many occasions. We've heard about your church attendance, heard you quote scripture, and seen a Bible in your home. However, there are 2 major components that are reflected in the life of a Christian. One is head knowledge of God and His Son, and the second is heart knowledge of Jesus and His Father. The manifestation of this heart knowledge comes from loving your neighbor as yourself. But all we've heard is that in these 2 trials is you hating the police, you hating the people at Sunnyview Church, even the pastor, and you've even transferred this hate to people you didn't even know in that incident in the ambulance. But there's still hope for you. It is not too late to confess your sins, which is the first step to your forgiveness. The second step is to repent or turn away from your evil ways. If you do this, God is faithful and full of grace and mercy to truly forgive you. The gates of heaven can still be open to you, and you can escape from eternal hell or damnation. It's up to you, and it's not too late. Steve Pankey, God is waiting. Thank you, Judge Kern.
Thank you, Judge Kearns. If I had an opportunity to address the defendant, this is what I would say. So many thoughts go through my mind. Every time I hear Janelle Matthews, as mom, I remember much. Yes, she's feisty. Yes, she's opinionated. But she's also tender-hearted, sensitive, and loving. I cannot at this moment say that I forgive you, Steve Pankey. How you ended Janelle's life. God will forgive you. We all know that. But He's waiting for repentance and a heart that wants forgiveness. I hope in the days ahead you will hear and obey what God is telling you, and that His word will penetrate your heart. Thank you.
Thank you, ma'am. Counsel, Mr. Pankey, dispensing with the captions. I'll read the jury verdicts in reverse. Jury verdict count 4, false reporting to authorities. We, the jury, find the defendant Stephen Dana Pankey guilty of false reporting to authorities. Jury verdict count 3, second-degree kidnapping. We, the jury, find the defendant Stephen Dana Pankey guilty of second-degree kidnapping. Did the jury unanimously find beyond a reasonable doubt that the defendant used or possessed or threatened the use of a deadly weapon? Answer, yes. Jury verdict count 2, murder in the first-degree felony murder. We, the jury, find the defendant Stephen Dana Pankey guilty of murder in the first degree, felony murder. Jury verdict count 1, murder in the first degree. After deliberation, we, the jury, find the defendant Stephen Dana Pankey not guilty of murder in the first degree after deliberation. Are these your verdicts? So say you and so say each and every one of you. Counsel, do you wish me to poll the jury?
Yes, sir.
And jury number 1, is this your verdict and the verdict of the entire jury? Jury number 2, is this your verdict and the verdict of the entire jury? Jury number 4, is this your verdict and the verdict of the entire jury? Jury number 5, is this your verdict and the verdict of the entire jury? Jury number 6, is this your verdict and the verdict of the entire jury? Jury number 7, is this your verdict and the verdict of the entire jury? Jury number 8, is this your verdict and the verdict of the entire jury? Jury number 9, is this your verdict and the verdict of the entire jury? Jury number 10, is this your verdict and the verdict of the entire jury? Jury number 11, is this your verdict and the verdict of the entire jury?
Yes.
Jury number 12, is this your verdict and the verdict of the entire jury?
Yes.
And jury number 13, is this your verdict and the verdict of the entire jury?
Yes.
Thank you. Ladies and gentlemen, let's say thank you to you and the alternates who spent a substantial, not only amount of time, but effort and discipline and consideration of this case. Now, the question may arise about whether you can discuss this case with the attorneys or anyone else, and the answer is that it's entirely up to you. It is proper for others to discuss the case with you, and you may talk to them, but you need not. If you talk to them, you may tell them as much or as little as you like about your deliberations or the facts that influence your decision. If any person persists in discussing this case over your objection or becomes critical of your service, either before or after any discussion has begun, I want you to report to me. You will receive a certificate of appreciation. It has a powerful quote. I'd like to read it to you. Trial by jury is more than an instrument of justice and more than one wheel of the Constitution. It is the lamp that shows that freedom lives. And it's a sacrifice that you each made individually that made a reality in this case. So I say thank you for your time and dedication. In a moment, I'm going to go back into the jury room. I'm going to begin to visit with you shortly, provide as much information as I can. If there's any alternates that wish to join us, they're certainly welcome to as well. Let me start out by saying this. The Matthews family, Mogensen family, families of faith that have shown incredible grace, courage sitting through this trial, 2 trials. But even prior to that, from the information I have in terms of dealing with a tragedy, it's unspeakable to think of the loss of a daughter and a sister, particularly in that manner, unknown answers for so long. You know who the who is, and you know the why. On behalf of the state of Colorado, you have our condolences and our hope. I don't know if closure is really the right word, but some sense of finality for your daughter and your sister. I don't know what happens from here. I understand the appellate process will play itself out. Our jurors worked hard, and I commend them. Take care of a few formalities first, Mr. Work, with respect to restitution.
Judge, at this point, I am not in a position to be able to address restitution. What I would like to be able to do is file a notice of restitution within 60 days with the authorization of the court. I know that there is going to be some, but I am not ready to address the restitution issue today.
Any objection to that procedure from the defense? If you can make a record regarding the nature of the restitution, I think that would be sufficient.
I think largely the nature of the restitution would be any funeral and burial expenses that the Matthews incurred in the burial of Janelle, and perhaps any lost wages that were suffered as a result of being here. That would be the extent of it, I believe.
I know that the timeline for restitution requests at sentencing have changed just a little bit. So I think that 6 days would give the defense enough time with 30 days if there's any objections.
I'm going to have to short it up.
And that's fine. I was going to say 60 days is probably too long. If the court would give me 30 days, I can comply with getting something filed one way or another within 30 days.
All right, I'll give 30 days for the people, 30 days for the defense. To be clear, the court is ordering restitution on today's date, the amount of which will be determined at a later date. We'll have that hearing within 91 days of today's date if requested.
Yes, sir.
As to count 4, court will close that count out with credit for time served. As to count 3, that is merging with count 2. Mr. Pankey, consistent with the authority and the statutory requirements at the time of the offense, the court is imposing life, possibility of parole after 20 years. There is statutory fees and costs. The court will waive ADC fees. The court will presumably waive any further advisement regarding appeals. I understand he has counsel, and I presume that process will start.
Your Honor, we did speak with Lindy Frolick, who indicated that the proper procedure would be for us to request for the court to appoint the public defender's office in form of papyrus under Rule 12B, and we're happy to reach out to them as well, and I'm sure they can follow up with a written filing, and they'll do a conflict check. If there is still a conflict, then it'll come back to ADC. If there's not, it'll stay with the public defender's
All right, we'll appoint the public defender's office for appellate purposes.
Thank you. And is the court authorizing under 12B to proceed in form of papyrus?
Yes.
Thank you.
It's been a long time. I heard what you said, Mr. Matthews. I'll be clear. I heard clearly what both of you said. Yeah, my condolences. Sentence of the court.
Steve Pankey was sentenced to 56 years in prison for the abduction and murder of Janelle Matthews.
Please be seated. For the record, both assistant state attorneys are present, all for defense counsel, and Mr. Rogers. Mr. Rogers, is there anything you'd like to say prior to sentencing, sir?
No, sir.
Okay.
Rogers has, I do have one thing to offer, Your Honor. Having sat through this trial, handling this trial for these many years now, and also then Mr. Seaver's trial and the result and outcome, I would like to point out that the verdict in Mr. Rogers' case does speak volumes. While he was convicted of second-degree murder, it was without a weapon, and he was acquitted of the conspiracy. The jury specifically found that he had no weapon. I would like to ask the court to take that into consideration, as well as take into consideration the fact that Mr. Wright, who admittedly swung a hammer, and Dr. Sievers, is set to be sentenced to 25 years. The disparity in this is significant, and it gives the appearance of being punished for going to trial, which of course is not just. So I would also remind the court, in addition to the testimony presented today, which I understand we're not at a penalty phase, but there was information that we thought would be in the best interest to present. We asked the court to consider that, along with some of the testimony regarding from Ms. Schumacher as to Mr. Rogers being a good father, loving children, her children that were not his, not him having children, him having a child, excuse me. We would ask that the court not sentence Mr. Rogers to life in prison, not sentence him as a PRR, but follow the guidelines in this case and sentence him to a lesser term of years. Thank you.
Okay. I normally don't say much at these things, but given what you said, I feel compelled to. He's found guilty as a principal. I don't think you can compare all three of them. All three of them have different patterns. The state, since the beginning of time, has always cut deals with one defendant, and whether it's fair or not, or whether it's to get to the other people who are culpable as well, that's their business. It's different than the other two. Mr. Rogers and Mr. Sievers have been found guilty of different offenses, so they can't really be compared either at this point. So they're all three separate and distinct, and I don't think they can really be compared as far as punishment goes. I guess it is somewhat of a conflicted verdict, given the fact he's been found guilty of murder as a principal, but without a weapon, but a weapon clearly was used from the evidence. And I don't know if that was an attempt by the jury to, because they feel your client was taken advantage of because he's younger, or they felt he wasn't as culpable or as involved, or that they didn't like the fact that Mr. Wright got second-degree murder because there was no mention of a weapon, but the mention of what his charge was and what he pled to was mentioned. However, I will say I've been on a felony docket off and on now for a total of almost a decade, and this is probably one of the most horrific. I can only think of two that might be worse that I've actually had, and that's arguable. And the fact that even if it is as a principal, that he picked those suits out and he got the duct tape and he drove all the way down to Florida without giving time to either bag out of the plan or to not be involved anymore. He didn't. I am going to sentence him as a PRR. I am going to adjudicate him guilty of both counts. For the misdemeanor, it's credit for time served. There is $413 in court cost, a $50 public defender application fee, $98,015.14 in actual costs for the defense, $15,000 in attorney's fees for the defense, $15,551.28, was it?
Yes, sir.
Cost of prosecution, all other fines and fees that are ordered by the clerk that are mandatory will be ordered as well. I'll order and reserve on any restitution. I think a life sentence is warranted, and as a PRR is warranted, and so that it's clear on appeal, even if I didn't do the PRR, given this fact pattern and how horrendous it was, I think, and his involvement, I think a life sentence, even without the PRR, would be warranted. Sir, you have 30 days to file notice of appeal with the clerk of court right here in this courthouse. If you think this is an illegal sentence, we're going to take a set of your prints and your DNA as well. Anything further from the state? From the defense? Yes, ma'am. You'll forward an order? Okay, granted. And if your client, if we have time and the bailiffs think they can accommodate him, he can have a moment with his brother before they take him back after they're done printing him. And he gets all his credit as well. For the record, that is 1,389 days. Good luck to you, sir. Yes. Nothing further? Nothing further? Sure, absolutely. Do we need your client or? Okay.
Jeffrey Todd Bailey has pleaded guilty to homicide by child abuse in connection with the death of Madison Stewart.
Your Honor, this is a terrible crime for which there is no legal excuse, no factual excuse, no psychological excuse. And J.T. Bradley stands in front of you not offering an excuse. He stands up here pleading guilty as charged without negotiation, without recommendation. Your Honor, he's done 2 tours of duty in combat in the Middle East. He went to Afghanistan in 2005, went to Iraq in 2008. It's not an excuse, but it's a fact. Those tours of duty profoundly damaged this young man. Your Honor, November 22nd, 2005, he was on patrol with his unit in Afghanistan. I'm sure the court's aware, roadside bombs and improvised explosive devices are probably the biggest threat to our troops in combat over there. They're often activated by occasionally young people holding electronic devices that detonate them when American troops are going by. His unit's on patrol and they're driving down the road and he's on patrol and there's a young man, probably about 8 I think, holding what appears to be some type of electronic device. The young man ignores repeated commands to put the device down. His sergeant orders him to shut down. Get you done. It turned out the young man was holding a transistor radio. Now, I don't know what that does to somebody, but it damages them. It damages them in different ways. Some people deal with that in different ways. It's not an excuse for what my client did, but it's an explanation why someone who was nonviolent and someone who was a good, decent person came back a changed person.
I do want to start by expressing my remorse and my deepest sorrow. I knew Madison Stewart. She was about 5 or 6 months old. I was immediately attached to her. I have a son. He's 6 years old. Not just as a parent, but as an individual. I see my son as the most perfect little boy that I've ever seen. So, Madison Stewart, of course, is the most perfect little girl that I've ever seen. She had exactly the equal amount of love that I give my son. I spent every day taking care of Madison. I changed her diaper, I gave her baths, I played with her. Seeing her smile and laugh, and she was the most precious thing that I ever seen. No, she wasn't my biological daughter. She may as well have been, because I loved her so much. No, it doesn't change anything about what I've done. And I wish that I could offer some explanation for what I've done. And no, I'm not trying to shift blame on the fact that I have post-traumatic stress disorder. But what I've done is not out of any direct malice towards Madison, any direct anger towards Madison, any direct anger towards the family. It's not a temporary shift of having impatience with a baby or a child. It is a result of the fact that I have not been properly desensitized after I came out of the military. I have not been properly treated. I've been put on medications. I've been put on antidepressants, antipsychotics, anxiety. I've not received any real treatment for PTSD. Along with my brothers and sisters that are in the military, they too have not received proper treatment from the Veterans Administration for PTSD. So, I in no way personally asking for any lenience. I am accepting full responsibility for what I did. And I apologize to the family of Madison Stewart, to Miss Penny Stewart, apologize to my family, putting them through all this. And I can't express my remorse for what I've done. That's all I have.
Thank you, sir. I appreciate you putting your life on the line for our country, for this court, for this system of justice we have. And while your PTSD diagnosis may help explain your tendency to have explosive anger, you're still the one who made the decision to put your hands on this beautiful child and assault her, which directly led to her death. You are responsible for your own actions, not Iraq, not Afghanistan, not that 8-year-old boy holding a transistor radio. Nothing I can do will bring Madison back. It's a senseless act. It's a horrible act. cowardly act, deplorable. You know, we're forgiven for our sins, but there's consequences for our actions. This shameful act that you did, you're going to have to live with for the next 32 years in jail. Good luck.
He was sentenced to 40 years in prison. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.